Hello and welcome back to ICJ's course on litigation before UN treaty bodies. In the last video, we looked at treaty bodies, their role and importance for human rights work, including in particular litigation, as well as UN special procedures. In this video, I'll speak about the concept of strategic litigation, explain what it is and what it may entail. Strategic litigation is a method of using the law in such a way that it helps to bring about systemic or structural change. Strategic litigation is also often referred to as public interest or impact litigation. Amnesty International, for example, considers litigation to be strategic when it is consciously designed to advance the clarification, respect, protection and fulfillment of rights, with the idea of such litigation being intended to change laws, policies and practice, and to secure remedies or relief following a violation. Specifically in the context of supporting victims of human rights violations, it means identifying a case that is representative of a broader problem or pattern of abuse and taking this case before domestic or regional or international courts or mechanisms to provide a remedy for the individual victim, but also going beyond the individual victim and addressing the underlying problem or root cause that resulted in the violation in the first place. For example, we may represent a victim who has been tortured by the police because of their sexual orientation. The victim requires and has a right to a remedy such as compensation, rehabilitation and restitution. However, we also look at the bigger picture, which might be that discrimination and violence against individuals for their sexual orientation is a common occurrence in a specific country. It could be that the laws in that country discriminate against LGBTQI people, or that institutions fail to protect them against discrimination, harassment and violence. When filing our case, we would therefore not only aim at providing our client with a remedy, but also to change the legislation and institutional frameworks that gave rise to the torture in the first place. A positive decision from a domestic or international court or mechanism can help us in our advocacy and communication to see laws and institutions reformed. One risk of strategic litigation is to lose sight of the individual needs of the victim and to prioritize the broader objectives of the case, or even to instrumentalize the victim to achieve these objectives. Moreover, a conflict may appear at a later stage of the case between the victim's interests and the overall goal pursued by strategic litigation. This is contrary to the duty owed to the victim as our client and their right to a remedy and reparation. A narrow approach to strategic litigation may furthermore result in a very narrow case selection strategy and in the exclusion of cases because they are not considered to have sufficient strategic value or because a client may be considered not to fit a specific strategy. As a result, fewer cases are being litigated, as would be the case under a more victim-centric litigation strategy that is guided by the merits of the individual case and what can be done to support the individual victim, rather than only strategic motivations. This victim-centric strategy still leaves room for considering how to make a case strategic. More often than not, cases involving human rights violations by their very nature will have a strategic element to them. We just need to identify it. For instance, cases of torture frequently include a systematic lack of adequate investigations by law enforcement authorities or the absence of a definition of torture in accordance with international standards. These are both elements that could be addressed in any torture case, irrespective of the circumstances of the particular victim. Subject to capacity, it can also be strategic to take many cases from a specific country to the treaty bodies to illustrate the scale of the problem, to highlight patterns of conduct, or to demonstrate the extent of the impunity in the country. The victim's or client's well-being and safety should be at the forefront of any litigation process and need to be regularly assessed. It should also supersede any potential strategic goals, and if a victim involved in litigation is no longer willing to support a specific aspect of a strategy, for example, the communication strategy that uses the client's case as an example to highlight a particular problem, this must be respected. Prior to litigating a case before a human rights treaty body, it will be important to consider, together with the client, the objectives of the litigation process, in particular where these objectives go beyond a remedy for the individual harm, and to make sure that the objectives of the client are aligned with those that we are trying to achieve as human rights lawyers and defenders, or those of the organization we work with. We need to develop a plan for the litigation process that spans from the moment we take the case to filing a case with the treaty body to the moment we receive a decision from the treaty body. That implies that we need to prepare not only the filing of the complaint, but also for the implementation of a potential positive finding by the treaty body along the lines of the remedies we requested. This should not start only on the day we receive the decision. We equally may need to prepare for the possibility of receiving a negative decision where the treaty body does not find that a violation has been committed. We need to consider the resources available to maintain a case throughout an often lengthy process. As we will see, cases before treaty bodies will take several years. We had to wait 7 years for a decision in one case involving torture, rape and unlawful killing for the Human Rights Committee to render a decision. As just mentioned, we will also need to work on the implementation of the decision, which will usually require additional resources. Speaking of resources, it is important to remember that what makes human rights litigation, including strategic human rights litigation, potentially different from other cases in terms of resources is not only that they are likely to take a very long time, but also that all litigation needs to be done in one of the Secretariat's working languages, English, French, Spanish or Russian. This also means that all documents will need to be either drafted in one of these languages or translated where they are in Arabic, for instance. If necessary, we need to identify potential sources of funding and other support, where we have the option of filing the case with several treaty bodies, for example, both the Human Rights Committee or the Committee on the Elimination of Discrimination Against Women, CEDAW. We need to assess the overall context, the client's chances of success and likelihood of wider impact, the admissibility requirements and the overall duration of the case. Where we know, for example, that a committee has already decided several cases from a particular country, this may be beneficial to opt for this avenue, as it suggests some familiarity of the committee with the issues and the overall context in which a violation has taken place. However, a more specialized committee, such as CEDAW, may be better placed to take into account, examine and analyze specific dimensions of a violation, such as, for example, sexual and gender-based violence. This may then result in opting for CEDAW to ensure more targeted remedies and recommendations on what measures the state should take to address structural shortcomings and to prevent repetition. For litigation to have an impact beyond the individual case, it may also be necessary to address common cultural stereotypes enshrined in society, as well as policies, and therefore go beyond pure litigation and to employ broader advocacy and communication strategies around the issues the case is seeking to address. As such, strategic litigation is one of several methods in the toolbox of human rights lawyers or organizations to achieve change, and strategic litigation cases are usually part of a broader strategy to make that change happen. Strategic litigation cases often require multiple layers of intervention and involve a range of actors at national, regional, and international levels. As mentioned, the cases may also require significant resources requiring specific outreach to donors. To tackle these challenges, it is best to work in a broad network of support, which can include domestic, regional, and international lawyers and human rights organizations working together. Each actor has an important role to play, with national level actors having better insights into and understanding of the human rights situation overall, the applicable legal frameworks and functioning of the judiciary, and usually they have closer links to the victim and affected communities. They might also be in a better position to identify targets for advocacy, navigate a country's media landscape, and overall be able to contribute to policy and public opinion. International NGOs and lawyers can support a case in identifying relevant legal avenues at regional or international levels, provide advice on international legal standards, help facilitate access to treaty bodies and relevant meetings in Geneva and New York, and provide a network of support that goes beyond law and justice, including, for example, medical legal expertise and the provision of such support to victims. Donors may help to support the entire litigation process or specific aspects of it, such as payment of lawyers' fees or funding of advocacy and communication campaigns supporting the case. It may also be relevant to explore whether organizations or individual experts can support the case by making so-called amicus curiae interventions at domestic, regional, or more recently also international level. The UN Human Rights Committee, for instance, now allows third parties who are not part of the case itself to submit such interventions, which can be very useful to support a specific argument or claim made on behalf of the victim. An example of how the engagement of UN treaty bodies in strategic litigation processes can make a difference are the efforts undertaken by the Open Society Justice Initiative in collaboration with several domestic NGOs and lawyers in Kazakhstan and Kyrgyzstan in Central Asia. In both countries, police torture in detention is a significant problem, as is the lack of independence of law enforcement and the judiciary. So for victims and their families, UN treaty bodies are the only international avenue for individual complaints. Open Society and domestic NGOs and lawyers filed numerous complaints on behalf of survivors of torture to the UN Human Rights Committee and the UN Committee Against Torture. Following decisions from both committees finding that torture occurred and reparation was owed to the victims, the courts in Kazakhstan found that decisions of UN committees are binding and need to be complied with. Victims then received compensation for the torture committed. In Kyrgyzstan, the court similarly found UN committees' decisions to be binding, and the NGO's litigation contributed to significant changes in the law and in the constitution. So to sum up, strategic litigation can be pursued before domestic, regional and international courts or mechanisms, or in a combination thereof. Its goal is to have an impact beyond the individual case. Strategic litigation cases should be embedded in a broader strategy that includes advocacy and communication around a specific message the case is seeking to convey and achieve. The needs, interests and rights of the victim as the client should always be at the center of the litigation process and therefore should guide all actions taken throughout the process. As part of the preparation for the litigation, we need to consider funding and other sources of support. Choice of forum is important in the sense that the more specialized the committee, the more likely that you will get a decision with targeted and detailed recommendations for change. Don't think you have to do it all yourself. As human rights litigation, including strategic litigation, can be a lengthy undertaking requiring expertise in a range of fields, it is best to work in a network of support. There exists a range of specialized international NGOs who can support domestic organizations and lawyers and who can help in developing a strategy and overall strengthen litigation at the international level. This brings us to the end of the second video lecture. You find more information in the notes included in this video, much of which, unfortunately, is only available in English. In the next session, we look more closely at the different stages of a complaint before the committees and how to structure a complaint. See you there.